let us start. We are already a bit late. So don't believe that for this second session we have only one speaker, even if it is the best speaker that you can imagine, as you will see. So we have here physically and two other persons virtually, and I start to introduce Catherine WOLLARD. Catherine is the director of ECRE. ECRE is an NGO, the European Council on Refugee and Exile. And I always say, not because I want to flatter Catherine, that ECRE is an extremely impressive NGO. The quality of the papers that they produce, the level of analysis is absolutely remarkable. And I have to say that I try to swallow a lot of legal literature, and when I read the papers of ECRE, I have very often the impression that they are better than many papers written by academics or researchers. So really, thanks a lot, Catherine, for accepting once more to be with us. And one advice that I can give you, if you are not yet registered, if you are not yet subscribed to the ECRE newsletter, every week you have one more policy newsletter and one more legal newsletter, do so. And read in particular the editorial that Catherine is very often proposing to the readers. Then we will have two persons virtually present. We will have Susan FRATZKE from the Migration Policy Institute, which is a think tank, originally located in the US, but that has created a branch in Europe. And finally, we have somebody from the UNHCR, not Stefan Meyer, because Stefan got vaccinated, but unfortunately got sick because of the vaccine. And he is replaced by somebody from UNHCR, and I got the information now. I even do not know who that person is, but I will ask kindly that person to introduce herself. Of course, I don't have to introduce UNHCR. Just the point that their Brussels office is dealing with the European Union and is, of course, a very important office. So I think that maybe you have some technical issues to solve, to be sure. Therefore, I give the floor to Catherine to start with her for 15 to 20 minutes. Thanks a lot, Catherine.
Thank you, and it's my pleasure to be with you all at this important date on the calendar for the Odysseus Summer School. In my comments, I'm going to cover three topics. First of all, our assessment of the Pact. Secondly, our alternatives and our strategy in terms of when we're confronted with this Pact. And then thirdly, I'll conclude with a few predictions on our side. You've heard in the last session quite a few predictions about where things are going or not going, and I'll add my thoughts on that. So ECRE, as some of you may know, we're an alliance of more than 100 NGOs in 40 European countries, so all the EU member states and then other European countries, including Turkey, Russia, the countries of the Western Balkans. And our focus is on defending and promoting the rights of forcibly displaced people in Europe and in Europe's foreign policies. I mention that because what I say is based on our assessment of the Pact, looking at it from a fundamental rights perspective, looking at the impact on protection in Europe. I also say that because on these issues, there are multiple conflicts going on in Europe, and sometimes very deep conflicts, and sometimes conflicts that even become violent on the issues of asylum and migration. And as ECRE, as an alliance, we have many members that are refugee-led organisations. We have others with different backgrounds. We're not neutral in that conflict that's taking place. We're very much on one side, and that will become apparent from my comments. Overall, our assessment of the Pact is relatively negative, even though we understand the political constraints that the Commission and then the co-legislators are operating under. One positive element I did want to mention at the beginning is not really a legal aspect. It's a political question and a question of narrative. Commissioner Johansson, the Commissioner for Home Affairs of the EU, has throughout, since she assumed that role or was given that role, that poisoned chalice, we might say, one of the things she's done, I think, is come with a more positive rhetoric, a more positive narrative about asylum and about migration more widely. And one of the things that she is explicitly trying to do is to normalise this policy area. And all of that we consider quite important, because if this is treated as a particularly difficult, particularly problematic policy area, or an area which is only a problem, as I think one of the questioners raised in the last session, sometimes it can be seen as that. And I think there's also a risk that if things operate in crisis mode, bad decisions can be made, and also bad law can be made. And processes may follow different emergency forms of lawmaking. And this is what we saw in the period 2015 to 2016. So I think that is something that's welcome, is an attempt to sort of calm down and normalise this policy area. So that was a positive remark. Now, now let me move to some of our comments about the Pact. I think overall, one of our concerns is that the vision in the Pact, or the vision that the Pact embodies, actually contradicts this somewhat more positive approach. And we see that the Pact is a continuation of a strategy that has been rolled out in Europe over recent years. And that's a strategy of attempting to prevent the arrival of people in Europe. And then, as a second arm, a second element, to prevent onward movement within Europe, which is the so-called secondary movement. For various reasons, we prefer the term onward movement, because often people have had long and arduous journeys before they get to Europe. So it's as though they don't exist before they get to Europe, and then the second movement is often the 20th or much longer. And there's an idea that Europe can manage this area and that it should offer protection, but only if nobody arrives. So I think this becomes somewhat contradictory. We also see, similarly to the 2016 legal reform package that was launched and that will also be the subject of your course, I imagine, because many of those, or certain of those legislative proposals are still on the table. But 2016 and the Pact of 2020, we see attempts to use legal reform to resolve political conflicts. And this doesn't always make for good law. And I think there's also an underlying question that sometimes those political conflicts can't be resolved, and there may be irreconcilable differences between the member states. And then legal proposals are put on the table that attempt to deal with those conflicts in legal form. So let me give a few more detailed comments on 4 elements of the Pact, and I'll just give our take on some of the things that have already been presented. So the first element is the borders piece. There is very much a focus on the borders. There's a focus on keeping people at borders in the Pact proposal. There's the new screening regulation, which I imagine you'll look at in some detail in your discussions. And then after that screening process, some people, or more people than currently, will be channeled into an asylum procedure or a return procedure at the border. So these 2 new border procedures I say new, I'll qualify that, but those two procedures are part of the amended Asylum Procedures Regulation. And the rule on that is not as wide as we feared. In the discussions before the Pact, certain member states were proposing mandatory use of border procedure for everybody arriving, which would have been essentially the Greek model, or some even more, even wider version of it. In the end, what we have is that those people from countries where the protection rate is 20% or lower will be channeled into the border procedure in normal times. In crisis times, that becomes 75%. So the concern we have on that, I would refer to various documents we've published. One is called Border Procedures and Not a Panacea, that you can get the argument there. And then an assessment that we did for the European Parliament on the implementation of the border procedure that already exists under the Asylum Procedures Directive, Article 43, looking at how member states use border procedures currently, because currently it's optional. The proposals make it mandatory for this certain category of people. Our concerns about this are that border procedures are not fair. Due to the short time limits that are applied, because procedural guarantees may be either absent in law or hard to realise in practice, so such as access to legal assistance. Border procedures always involve detention. The study that we did for the Parliament shows that in practice, member states will almost always have a situation of detention, either formal or de facto detention, which is a situation of detention but one not declared as such. And then a focus on borders can mean that refugees are actually more likely to be targeted. So even though there's an attempt to present this as sort of filtering out the undeserving, if we look at previous attempts to put in place these models, it is often people with protection needs that are the ones that have to cross borders irregularly, as it's called, in order to seek protection. And the case in point is the EU-Turkey deal. Who's affected by the EU-Turkey deal? Overwhelmingly, it's refugees who are prevented from leaving from Turkey under that deal. And then if people arrive in Greece, it's Syrian refugees who are then intended to be sent back to Turkey. So the focus on borders, I think I would say as a sort of side note, there's a lot of debate about protection rates, and a lot of the proposals are justified through reference to these figures that very few people arriving in Europe have protection needs. Actually, the protection rate is historically quite high, and the figure often used is that only a third of the people are getting, in an asylum process, will have a positive decision. But hold on a minute, this is first instance decision making. So at first instance, it's about a third, but then a majority of the negative decisions will be overturned on appeal. So it's hard to track, but our claim is that it is likely that the majority arriving are still people who have protection needs and will get a positive decision from the court when you look at the full legal process, including second instance appeal and review decision making. This is also important because this is a basic element of any legal process. A higher court reviews the decision of the first court. It's not some special privilege that exists only in asylum law. It's also a human right, the right to an effective remedy. So it's important to look in detail at what figures are being used when protection rates are used. And we have a briefing on this you can find on our website. There's also other elements that mean the figures are something of a misrepresentation. So inadmissibility decisions where the case is not even examined on the merits are included as negative cases of people without protection needs. Well, maybe they had protection needs. A Syrian arriving in Greece who gets an inadmissibility decision under EU-Turkey deal is somebody who has protection needs, but will be included as a negative in the figures. So for qualifications, look at that. And then, of course, there's a risk of harm for people arriving if there's this focus on containment at the borders. It's the Greek island model that may be in the interests of certain member states whose real concern is onward movement, but of course for applicants and for other member states, it's negative. So there's one positive element, which is the independent border monitoring mechanism. You can see there's an NGO statement analysing this. We welcome it, but we also recommend that it covers all situations at the border, not just the screening part. And we have recommendations to improve the independence of those border monitoring mechanisms. Unfortunately, it seems that in the Council, the member states are very much opposed to this border monitoring mechanism, as they are to many different elements that involve monitoring what they're doing. So even this positive element might not make it through the negotiations. The second element that runs through the Pact is the emphasis on return and deportation. This is somewhat problematic because of, again, the reference to the decision-making and the protection rates which are used to justify this focus on return. In fact, many people do have protection needs. From our perspective, return is an element of asylum and migration policy. Under certain conditions, which are fair decision-making, dignified return procedures, return is part of the picture. I think our concern is that there's a disproportionate focus on it, and it's presented as though it were the solution to everything. I think there's also a risk, even for the Commission, in putting this emphasis on return, because so many resources and priority has been placed on return going back 20, 25 years. The reason it's difficult is because it doesn't lie within the power of Europe. It's the other countries to which people would be returned who may refuse to readmit their own nationals, or may certainly refuse to readmit third country nationals. I think there's also a risk that it leads to continued efforts to capture external policies and use them in this kind of deal making to convince countries to accept back their nationals. A third element I wanted to refer to is solidarity. So the main reference, this is covered in the Pact in the Regulation on Asylum and Migration Management, the RAM, which is a mega legislative instrument. We did an analysis of all the legislative proposals, and I actually wrote our legal analysis of that RAM proposal. As I read it, I couldn't decide, is this the sort of nadir of EU law, or is this a work of twisted genius that attempts to resolve irreconcilable differences in a legislative form? I would perhaps recommend you read our comments on it rather than the instrument itself. We've done you a favour there. What are the main parts of it? As we heard in the first panel, the basic rules that exist in Dublin III remain, including the first country of arrival principle. So our long-standing position is that deeper reform is necessary. And our understanding is that it was politically not possible, or the Commission would claim that it's politically not possible, to propose a deeper reform of the rules. The problem with Dublin as it stands is often that the hierarchy of criteria for deciding on responsibility is not respected. So at the top of the criteria is family reunification, the rights of children, and very often member states will go directly to the question of country of first arrival. On this, I would recommend an implementation assessment that we prepared for the European Parliament, which looks at the implementation of Dublin III, where that well-known facts about the lack of respect for the hierarchy. But the question is, if those remain the rules, will anything change? Will there be an opening up of family reunification, which is the first of the criteria and should be the one that member states go to first when allocating responsibility? There are some improvements. There's an expansion in the definition of family, and there's more appropriate evidential standards in place for proving family links. So that may open up family reunification. On the other hand, there are also negative elements which will increase the responsibilities of the countries at the borders. And this includes a 3-year period of responsibility for those countries. It's not the permanent responsibility that was proposed under Dublin IV proposal, but still it's a significant extension. And then the take-back request, which is currently when somebody engages in onward movement, they're found in another member state and then they should be returned to the country of entry. The country where they are will issue a take-back request. That becomes a take-back notification. So for instance, that person who's turned up here in Belgium and Belgium wants to transfer them back under Dublin to Italy, Belgium will simply issue a take-back notification rather than a process which is a more mutual one. So the attempt is there to enforce that element. And again, we see the priority, right or wrong, of onward movement for certain member states, that they want to end this process or to limit the onward movement of people across Europe. There's also elements in it, there's a lack of consistency with the jurisprudence coming out of Luxembourg. I won't go into details there, but refer to the MA and CK decisions, which are not reflected in the draft. And then the compensatory element is the solidarity mechanisms. So the basic rules remain the same, but in a welcome change, there will be 2 solidarity mechanisms, one for situations of search and rescue and one for migratory pressure. And those mechanisms, from our perspective, are something welcome to increase solidarity. And certainly a mechanism for search and rescue is extremely important because we need a more predictable situation when people are arriving and being disembarked in the member states. Nonetheless, I think the question is this enough to persuade the countries that currently consider Dublin to be unfair? You've got a preservation of the rules and then the 2 solidarity mechanisms. In the solidarity mechanisms, there's also different types of solidarity, including return sponsorship, as was discussed in the previous session. I won't go into details with that. Let me conclude the first point on our assessment of the Pact with just a small reference to external cooperation. So the Pact is part of what is called a comprehensive approach. And for us, actually, it's not so comprehensive because the element that is about making asylum function in Europe is not as present as it could be, but there is this focus on increasing partnerships and cooperation with countries outside Europe. And in a way, it's unfortunate that the most important of the legislative proposals, the first substantive article of it is about the responsibilities of countries outside Europe. So that in itself, if you look at Article 3 on partnerships, even if it's largely rhetorical, it's still, I think, important in that this is the way forward that's seen. We wouldn't say it's completely without legal value. I mean, this is a codification of the role of the Commission and of internal affairs policymakers in external partnerships. So it does have a certain value. Of course, this is not something new. It's something that's been attempted for many years to get the cooperation of countries outside Europe. From our perspective, it's something that undermines the objectives of external policies, be they development, security or trade. And it's also something that's rather damaging to the EU at a time when the European External Action Service, after 10 years, is in place and should be functioning. On the other hand, member states that have not been willing to invest in and to allow Europe to develop, the EU to develop its own foreign policy, now are uniting and coming behind the idea of EU foreign policy because it's about, or increasingly about, prevention of migration. So there's a dilemma there that we can discuss. So let me conclude then with just a few points on our response and predictions. So in the face of all of this, as civil society organisations with a particular agenda, we've been pursuing a dual strategy. And I actually would be interested in hearing from you as participants if you think this is wise. So on the one hand, we are engaging with the Pact and we're trying to be constructive. So we've proposed amendments, we've done analysis article by article. We're working with the two co-legislators to try to persuade them to accept the amendments that we've proposed. We managed to get more interest and acceptance from the Parliament, but quite a lot of discussions with member states, at least discussions. They're not necessarily accepting what we're proposing, but that's part of the attempt, almost on damage mitigation, to say if these legislative proposals are going ahead, then add in safeguards, remove the particularly pernicious concepts like return sponsorship, change the balance between solidarity and limit the focus at borders, different elements. On the other hand, the other element of the dual strategy is to continue to promote alternatives to the Pact and a different way of managing asylum in Europe. And on that, we proposed a set of alternatives when the Pact was announced before it was published, saying that it's time for a change of direction. The focus should be on compliance with existing asylum law and tackling the flagrant violations that are taking place, focus on compliance, put in place interim solutions on solidarity, safe and legal channels for asylum migration and non-asylum migration, where the numbers of legal places have gone down rapidly over recent years. Inclusion of people in Europe, beneficiaries of international protection through rights, particularly right to housing, right to employment, respect, tackling xenophobia, and regularization, which is highly sensitive, but in our view has to be on the table. And then a foreign policy that's based on tackling the causes of displacement, not diverting political priorities and funding to prevent movement of people who may at some point eventually be coming to Europe. So even though we had very little success, practically zero, I would say, in convincing the Commission to adopt any of those proposals in the Pact, we continue to persist with this, partly because while the Pact is being negotiated, we're not operating in a vacuum. There is already complex, extensive EU asylum law. And of course, we see day to day member states acting as though they had no obligations. So this is one part of it. But if the Pact is never agreed, then alternatives, a plan on search and rescue and other things need to be on the table. I think there's also danger in this rhetoric of saying the system has failed. Yes, there's problems, but if you say the system has failed, again, it suggests to states that they don't have to follow. It's kind of blackmail rhetoric, let's say. And finally, predictions. What will happen? I think you had in the previous panel those who are much closer than we are to the negotiations. I think it's clear that the Pact as a whole package being agreed by all 27 looks very unlikely. For the Visegrad 4 plus 2, we would say there's the Visegrad 4 and then there's Austria and Denmark who are largely share their position. And even of the Visegrad 4, you could argue that a country like Slovakia, it may be easier to convince of certain elements than a country like Austria now. So you've got that group. Probably nothing will be enough. in a number of those countries, they don't want Europe to be offering asylum. They're perhaps more opposed to refugees than to migrants. And they compete for migrants as well. And of course, it's a question of choice. But that idea that refugees are okay and migrants are not is reversed in a number of the countries there. So we may be looking at QMV, ultimately anyway. The other major conflict is North versus South. Now, mention was made of the Med 5. We would say the Med 6, because as soon as Portugal has ended the presidency, we can probably assume that they will be with this grouping. It looks on paper like a very bad deal for the South. That's our perspective. But some of those countries may be persuaded, or at least on some elements. And I think the opposition is not as strong as it was when the 2016 proposals were launched. So for instance, with Greece, there are things that can be offered to Greece that might persuade them. And if you look at the situation in Greece, they basically have this model anyway in virtue of the EU-Turkey deal, but without solidarity. So maybe they would be persuaded to accept it, given that it's what they're implementing, but there would then be some solidarity. In two of the countries, they have prime ministers who are pretty keen on big EU jobs. Could that be something that persuades some of those countries to get on board? I think overall, a lot of it will come down to Italy. And the whole question of Dublin and solidarity is extremely political in Italy. This is an issue that can, I know some of you in the group are probably Italian, I'm sure you can say more about it. It's an issue that can win you elections. If we look at the 2017 elections, Salvini, Lega and Cinque Stelle, those two parties made a pact on the basis of migration, and Dublin was a key issue in the election campaign, or the resistance of Dublin. So it's going to be very hard to persuade Italy to accept something that preserves the same rules, but maybe it's possible. Finally, in the European Parliament, things are very different compared to the parliament that was in place when the 2016 proposals were launched. At that time, Parliament reached agreement very quickly. It was efficient. I think it was the only institution that came out of the so-called crisis looking good. They quickly reached positions on the legislative proposals, and they were largely positions that preserved asylum in Europe. This is, and we say that but also because they accepted so many of our recommendations that we were pleased with the Parliament positions on that bunch of proposals. Now it's rather different. And it's not so much because there are more extreme right parties in Parliament. They didn't do as well as predicted, with the exception of the Italian contingent in the 2019 elections. What has changed is that the centre-right EPP group is far more hardline on this issue. So it will be more difficult for Parliament to reach a position, and it will be less likely that the Parliament positions are progressive and supportive of fundamental rights. So Parliament is a different kettle of fish. What we're likely to see, I think, is mini deals. Is over the next few years, a few deals similar to what's just been done on the Asylum Agency that was already mentioned. And I think there the question is, what is the nature of those mini deals? The Asylum Agency agreement, the one thing that's put on hold and removed is the element that we were most positive about, which was the monitoring mechanism and giving a monitoring role for the EU Asylum Agency. And that's on hold and presumably won't come back. I mean, it's a more complicated, but that. So I think it's going to then be a question of, if mini deals move, how can they be deals that present workable legislation on the one hand, but also preserve fundamental rights of those arriving on the other. Thank you.
Thank you very much, Catherine. Now I go to the online persons. I don't know whom of the two persons is ready to intervene, and I rely upon our technical team. Who could start?
Good afternoon. I think my microphone is working, but Susan, if you would like to go first, please go ahead.
Please, yeah.
Go ahead.
Okay, thank you very much. And to introduce myself, my name is Alexandre Mberakos from the UNHCR. I'm working in Stefan's team. He sends his sincere apologies for not being able to join, and I hope that my last-minute intervention will live up to those standards. So I do work in the Policy and Legal Support Unit. It's the unit dealing with EU affairs here in Brussels. And similarly, I would start by perhaps zooming in on some elements of the Pact that are of particular interest. We call them crunch issues. So, for example, access to territory, the asylum procedures, including the border procedure, and the solidarity elements of the Pact that Catherine has so eloquently explained. But first, perhaps I can highlight a few recent statistics. Just on the 20th of June, UNHCR released its Global Trends Report. This is an annual report that looks at the situation of displacement globally. And quite worrying figures because despite the pandemic, the number of people fleeing wars, violence, and persecution has risen since 2020. Nearly 82.4 million people now, according to this report, are displaced. This is a 4% increase on top of the already record high 79.5 million at the end of 2019. The report shows that by the end of 2020, there were 20.7 million refugees under UNHCR's mandate. It's important to recall also that the vast majority of the world's refugees, nearly 9 in 10 refugees, so it's about 86%, are hosted by countries in neighboring countries, also low and middle income countries that have their own crises and situations to deal with. And all this to say, for the Pact, the current situation in Europe is comparatively manageable. And now is the time to continue to build on Europe's protection system and not just on the external dimension. I think there are three key messages that UNHCR has been putting across. So the Pact, although it's difficult to achieve, it's not fully satisfying for all. It presents an opportunity and an important starting point. And we view that ongoing negotiations are a real opportunity to define some common ground on asylum matters in the EU. As Catherine mentioned, many of these debates have been ongoing since 2016. Second, on preserving the asylum space, Europe has a long history of offering asylum and protection to people in need. And this is a time to really reiterate such common European values and maintain safe access to territory for asylum seekers. And we always say this should be coupled with fair and fast procedures and predictable models of intra-EU solidarity. Now, of course, compromise is needed to find common ground. In my current position, I focus on the Council of the EU. So this is the sticky member states with all of their varying positions, the 27 needing to come to an agreement. So we do encourage member states to find a common ground and define a pragmatic and fair, humane asylum policy in Europe. So to go on a bit more of a micro level to some of the different legislative proposals, perhaps on access to territory, it was already mentioned, the screening regulation. In general, UNHCR welcomes the proposed screening procedure foreseen in this regulation, in particular because it supports the provision of an early vulnerability screening. And within that, it has proposed cooperation with, for example, specialists like child protection services and anti-trafficking experts and the authorities. A streamlined process on arrival is something UNHCR have been advocating for quite some years. If you look at 2016, a paper was released called Better Protecting Refugees that highlights the need for these different various front-loading steps to have a very efficient procedure later on. So these include, for example, identification of specific needs and family links, proper referral to reception centres, counselling and information provision. And while the Pact includes some of those elements, of course, there is always room for improvement. Particularly access to territory has been increasingly called into question, and particularly by the repeated reports of pushbacks at the EU external land and sea borders. And such deterrence approaches perhaps result from a dissatisfaction or inefficiency with the asylum system, which is all the more need to have well-functioning systems in place in Europe. UNHCR is very concerned by these different reports, and investigating and halting this practice must be a priority. And obviously, access to territory must be maintained even in times of a pandemic. And it has been shown across Europe that access to asylum procedures can still continue even in times of border controls and broad closures of the borders. In particular, on the screening regulation, we would echo the sentiment that an independent national monitoring mechanism is an incredibly important tool for the protection-sensitive border management. We do want member states to put this in place without delay, particularly in light of these pushbacks. And I could perhaps refer you to a joint consultation on this INMM, as we say, between OHCHR and UNHCR, and that's available online. I think one of our main concerns regarding the screening proposal, but also extended into the APR, so the Asylum Procedures Regulation, is the fiction of non-entry. So within the Pact, there is a pre-entry fiction, and this raises several concerns, for example, reception-related concerns, as the pre-entry fiction, particularly in the screening of 5 days, potentially excludes a number of the rules and safeguards that would ordinarily apply under EU asylum law. And it has also triggered proposals for externalization, and UNHCR does not support these externalization proposals of asylum obligations. I'm sure we've all been following the situation between Denmark and so on. Our position is that the international legal obligation of states remains applicable despite this artificial construct of this non-entry fiction, and that states must provide asylum seekers admission, at least on a temporary basis. Otherwise, the right to seek asylum in itself and the principle of non-refoulement would otherwise be rendered meaningless. I think one element in the screening that is also regretful is the notable absence of access by NGOs and international organizations for the purpose of, for example, information provision. It's not guaranteed in the Pact. So we would also encourage member states to grant access to border reception and processing facilities for the relevant actors. Moving on to procedures, and of course the Pact's border procedures are quite complex. It's been mentioned already, this complex plethora of different interlocking legislative proposals, but the Pact proposes a mandatory border procedure in 3 instances. So the first is misleading authorities, a danger to national security or public interest, and this interesting country with a recognition rate below 20% that Catherine had already mentioned. In our view, fair and fast asylum procedures, including potentially border procedures if done properly with the proper procedural safeguards and that adhere to international and EU law, are possible. This is specifically in the concept of mixed and onward movement dynamics in the EU. So as we know, one of the part of the package, the so-called Eurodac regulation, which is still stuck in the package approach, would allow member states to effectively count the number of applicants that are in Europe per applicant and not per application. So sometimes it results in multiple different 3 or 4 time registering of the applications. That is very difficult to quantify. Obviously, member states are not able since 2016 to move ahead with this, and we're concerned that externalization considerations will gain traction among member states should the negotiations on asylum procedures within the EU not progress. In general, our approach is based on a discussion paper called Fair and Fast, and it proposes in-merits asylum procedures with full procedural safeguards to quickly identify those whose claim is manifestly unfounded or manifestly well-founded. While these safeguards need to be adhered to, the use of accelerated procedures can also be given to well-founded cases so that they don't have to wait, they can access protection as fast as possible. I would say that overall the reduction in safeguards compared to the current APD, the Asylum Procedures Directive, is a concern. For example, there's this concept of no suspensive effective appeal within the border procedure, which essentially means that after an appeal is done, an individual can be returned without having their appeal finalized. The final point on this is the admissibility considerations. So the Commission's proposal foresees in-merits decisions at the borders only in some limited cases, but it does still maintain the possibility for admissibility decisions at the border based on, notably, the safe third country concept. I think in general, we favor in-merit procedures over admissibility considerations, including in any accelerated border procedures. I think the main concern here is that the admissibility, particularly the mandatory application of a safe third country concept, can lead to the responsibility shifting towards other states with less capacities, and it can have an eroding effect on the international protection system. The use of these admissibility procedures is essentially another level, and we need to continue to caution against them. Obviously, personal interviews are critical to guarantee the fairness of a procedure and ensure that decisions are based on complete information. Maybe I can touch on this 20% channeling into the border procedure. Triaging, in our view, should be based on a proper caseload monitoring and analysis. So it needs to consider several different factors, including country of origin, the risk profiles, the degree of homogeneity in the overall protection rates. And while this 20% or lower could be a good starting point, it needs a closer look, notably as regards to the identification of individuals with risk profiles. So we can use the example of LGBTQI asylum seekers whose vulnerability might not be immediately evident, and these persons should not be included in a border procedure. We obviously welcome that unaccompanied children aren't included in the proposed border procedure, but we would also say that victims of trauma, trafficking, should also not be included because they're not able to meaningfully participate in such a time-limited procedure as this. To move on to solidarity, so the AMR, Catherine had called it the RAM, we call it the AMR, maintains in essence the existing Dublin system. Of course, there are some variations. Of course, the hierarchy of criteria and the principle that the first country of entry is responsible for an asylum application, this is essentially maintained. But we do also welcome the expansion of family, so siblings are also now proposed to be included. And particularly, we say that family considerations should take precedence over other elements, such as admissibility. And this is also where an early vulnerability screening and an early screening to determine family links is incredibly important. So those individuals can be relocated to rejoin their family. The flexible solidarity model is definitely something that member states continue to discuss. So there are essentially three different elements of it. One is relocation. One is this novel, perhaps the only really novel thing in the Pact, the return sponsorship. And the other one is other measures such as capacity building and so on. For UNHCR, I think we acknowledge that the proposal is nuanced. It's an attempt to replace the current arrangements. And crucially, we welcome the search and rescue element as a way to move beyond the current ad hoc system that we see playing out. Perhaps some of you remember in 2019, there was a so-called Malta Declaration where some member states gathered together to try and find a temporary arrangement for disembarkation over the summer. Now, only some member states volunteered to this, and we think properly codifying and having an effective and predictable solidarity mechanism is incredibly crucial. In conclusion, I think I won't go into too many extra details, but just thank you once again for your invitation. And I know that this is the first in-person meeting of the summer school, so I hope you enjoy it, and I wish I could be there in person as well. And with this, thank you so much for your attention, and looking forward to any questions.
Thank you very much for having replaced at the very last minute your colleague. We really appreciate that. Let's now turn to the last speaker, and Susan, I leave you the floor.
Great, thank you so much, and thank you so much for including me this afternoon. My name is Susan FRATZKE, and I am a senior policy analyst with the Migration Policy Institute in Europe. We are a non-political policy research organization that's based in Brussels, founded about 10 years ago now. And our perspective is a bit different from the other very valuable and important perspectives that you've already heard this afternoon. We, as I said, are a policy research organization, so we aren't coming to the issues that we study with any particular normative framework or approach. Our focus is really on how to build effective migration and protection systems. So the comments that I'm sharing this afternoon will be based on analysis and research that we've done over the last 6 years or so, looking at the implementation of asylum processes and procedures and policies in Europe. And I think throughout the other presentations and remarks that you've had earlier today and already on this panel, you've already gotten a lot of detail about the different measures in the Pact and the positives and negatives of them and various trade-offs, as well as the political negotiations and political difficulties in moving some of them forward. So I'll be taking a slightly different approach and looking a bit more at sort of what's actually happening on the ground. The Pact, as you've already heard, has really taken a very comprehensive approach to these issues and has really sought to make sure that all of the different policy pieces and measures are tied together in ways that make sense, that different procedures and policy areas are really linked to each other. So, for example, that a return decision is actually linked to a return procedure that will in fact be completed. It includes measures on improving monitoring and ability to detect and respond effectively to difficulties and challenges in asylum procedures when they arise. And this is all based on learning that's happened over the last 5, 6, 7 years since 2015 and even before. And as you already heard from Alexandra and from Catherine, a lot of these are things that aren't necessarily new. These are procedures and policies that the broad principles of them have broadly been there for several years, and the challenge has really been moving them forward at a political level. And I think we can sort of debate the exact details of how the different proposals have been structured, but I think broadly the structure of the Pact is quite practical in many ways and really seeks to address and act on many of the lessons that have been learned from 2015 and make progress in areas where we know progress is needed. But of course, the desire to push forward on these different areas has really been stalled due to the political negotiations that you already heard about this morning. And it's really the long-standing challenges and divisions that Catherine outlined so well already around things like responsibility sharing and border procedures that have held things up. And a lot of the conversation in Brussels and elsewhere over the last few years, both before and since the Pact was announced, has really been focused on, to what extent will we be able to break out of the political logjam and move forward on particular areas of the Pact, or move forward the whole set of measures as a whole. But what I'd like to, I think, just take a step back and ask and sort of leave in your minds as we look at the different merits of the different pieces of the Pact and how likely it is that one member state will be, willing to vote for it or not, or whether or not we'll be willing to use qualified majority voting, is to sort of take a step back and look at the broader framework within which the Pact is happening and sort of ask how much the political logjam and political debates around it really matter in practice. There are some signs that the politics are already beginning to shift a bit. There was discussion around the Justice and Home Affairs Council in June that there may be some willingness, for example, to break off some pieces like the EU Asylum Agency regulation and move those forward. But more importantly, I think we've already seen, and what we've really pointed to in our research at MPI, is a lot of movement and change that's already happening on the ground in a number of different areas, even when political negotiations have stalled. And this has begun to remake the area in which asylum policy is happening in Europe, even while these political conversations are continuing. And what we might see, sort of in addition to what Catherine outlined around different pieces of the package breaking off and moving forward, I think we'll also see an asylum field within Europe that's already been remade before that even happens, due to the progress and sort of changes in the situation that are already underway. And there are two areas in particular that I wanted to point out. The first, as Catherine and Alexandra already mentioned, is on the external dimension and sort of the push towards externalization. And I see this as sort of the negative side of this, practical push coin. So while there's an ongoing debate about border procedures and externalizing asylum applications in principle, and sort of what should happen, and how responsibility should be shared specifically at a context of an external border arrival, EU member states have already become much more adept at actually preventing people from reaching EU territory. And part of this, of course, is what we've been hearing over the last few months around Frontex and accusations and mounting evidence of involvement of pushbacks at external borders. But there's also the greater willingness and adeptness of member states in the EU to negotiate and carry out third country deals, and also agreements with third countries to engage in pullbacks and actually keeping people from reaching EU territory. There's been lots of talk about how numbers were rising again, of arrivals were rising again in May, but it's important to keep in mind that these are actually, as Alexandra said, still very small relative, of course, to 2015 and 2016 or even 2017, but also relative to the global refugee population as a whole. Just under 33,000 people have actually arrived to the EU so far in 2021. So what we've seen is that while member states are still debating the exact nature of border mechanisms and responsibility sharing, there's already been quite an effective push to prevent and make it actually much more difficult to reach the EU de facto and in practice. So that's sort of the negative side. On the more positive side, what we've been documenting over the last few years at MPI is actually quite a lot of innovation and improvement happening within asylum procedures and processes within the EU, sort of independent of what the legal frameworks say and sort of where the political negotiations have stalled. The aim, as Alexandra said, within an asylum process, of course, is to have a procedure that is fair and that is viewed as being robust by everyone who is involved, and as well as a procedure that's efficient and is able to get people into protection and have their claims heard quickly, and to come out with a fair decision without leaving someone in limbo for quite a long time. Processing times across the EU have improved and backlogs have increased. As Alexandra said, there's been a lot of efforts and investment in doing things to streamline processing arrangements through accelerated procedures that are implemented in a more thoughtful way that allows manifestly founded cases as well as manifestly unfounded cases to move through procedures much more efficiently. There have also been investments in many member states in things like digitizing procedures and digitizing case files and actually allowing cases to move much more quickly and efficiently through procedures in that way. There's also been investments in things like one-stop shop processing centers that have been implemented, for example, in Switzerland and in Germany, that actually bring together different agencies under one roof and allow them to cooperate on processing claims in an efficient way. These types of measures not only allow for more efficient procedures, but also more robust procedures because they allow much better communication between those who are involved in processing cases. And for example, in Switzerland have provided guidance as well for individuals on how their cases are being processed and up-to-date information while their claims are being processed. And so allow for also more information sharing with applicants themselves. EASO officers who have been deployed on the ground have also gotten a lot more experience and built relationships with frontline member states in providing support in that way. So on the whole, there's been quite a lot of innovation and progress around asylum procedures generally that has led to much more robust, efficient, and fair procedures on the ground. And I think as we look at the potential in this area moving forward, it's important to look at the progress of the European Union Asylum Agency regulation as well, and the likelihood of whether or not that may be broken off and be able to take forward separately. Because once that piece begins to move, I think it may sort of step in and help to increase and further the trend that we're already seeing of sort of innovation and progress on the ground. A new asylum agency, even in the absence of a monitoring and evaluation mechanism, which, as others have already said, you may not take effect immediately while the other pieces of the package are still being negotiated. We'll still have leverage on member states through things like being able to issue guidance or having some sway over things like funding allocations, and maybe possible through other measures that the agency can take, like information sharing, peer learning, to actually accelerate and bring about changes and improvements in procedures on the ground, even without the political movement on the legal procedures. So it's possible that in a few years' time, some of the more innovative approaches that we're seeing may be more standard practice and can perhaps contribute to actually bringing about a political shift, as the politics will then be actually needing to move to meet practice on the ground rather than sort of responding to a theoretical world and theoretical trade-offs. I would also note that I think the Commission also seems to be recognizing the need to keep things moving at a practical level as well. The Commission itself has invested in, for example, launching the integration plan, the strategy on return and reintegration, and more recently even the talent partnerships, which aim to open more legal pathways for individuals to come and work in Europe. So I think there's a broader recognition that, as Catherine had said, legal reforms may not be the only or necessarily the most effective way to resolve some of the political tensions that have really been inherent in the European asylum system and sort of the broader European project on the topic of migration in general, and sort of an increased willingness both on the part of Commission and a number of different agencies to focus and look at the practical level and what can be done there while the politics are sort of simmering and hopefully resolving themselves over time. I think one wild card to keep track of in terms of the likelihood of this sort of practical, pragmatic driven approach going forward is the situation in Afghanistan. I think there's some broader concern about as the US and allies withdraw from Afghanistan and the situation is likely to deteriorate, what will happen in terms of individuals who will need to seek asylum and seek protection and may be driven to do so if there's a shift in the security situation there, and that may have other consequences in terms of individuals seeking to find their protection in Europe, and may change sort of the practical situation that we're facing at specific border crossing points and put pressure under some of these new systems that are being developed before they've really had a chance to be tested and sort of solidify. So I think that's one sort of unknown in terms of what may actually be possible for member states as they look to move forward and advance on a more sort of practical and pragmatic approach to developing a common European asylum policy, and one that doesn't necessarily become as bogged down in some of the politics and legal dimensions that we've already heard about from Catherine and Alexandra and others. So I'll leave it there, as I know we just have a few minutes left for questions. Thank you.
Thank you very much. Let us indeed collect a question, and I turn first to the person following the online. No questions from the persons online. Okay, we will see a bit later on. So let's collect 3 or 4 questions from the audience here. I see one person here, there, and another person there. Let's start with you.
Hello. First thing first, thank you so much for your insightful presentation and information. My name is Sabeti Behzad. I came from Afghanistan. I wanted to ask a question from the Miss, if I do not make a mistake, Alexandra from UNHCR. As you know, violent conflict is one of the main root causes of migration. At least 3 to 4 SDGs have a direct connection to migration. And a great number of migrants in Europe came from war zones or conflict-prone areas, which United States have had intervened or have intervention by the name of regime change or democratization or whatever. But my question is that to what extent United Nations system could be a mediator to solve the immigration issues with collaboration of both United States and EC or European Commission? And don't you see the immigration as a big absentee in the SDGs goals? Thank you so much.
Thank you very much. There was a question there in the middle. Then Lillian has a question. Who else is going to raise the hand? Nobody for the moment. Yes, we will go there afterwards. Please.
Okay. Thank you so much, everyone. Really good interventions. I was especially interested in the comments from Catherine about what I kind of see as a politics of deterrence in the Pact, or at least the idea that it is based around the prevention of arrivals and really containment and encampment at EU borders, despite that kind of reassuring narrative from the Home Affairs Commissioner. So my question really has 2 parts. Firstly, do the speakers believe there's a fear from member states that a functional solidarity mechanism and potentially also better conditions at EU borders and even integration efforts like housing and jobs and more focus there would function as a kind of a so-called pull factor for people arriving in Europe? And secondly, if there is a sense, even if it's not explicitly said, that there is a politics of deterrence, how do the speakers believe that we can move beyond that? Is it about focusing on evidence-based migration policy, on labor needs? Is it about focusing on protection needs and the kind of vulnerability of people arriving? Or is it even, I think it was Alexandra mentioned the erosion of international standards. Is it a focus on upholding international legal standards? Yes, thank you. So any comments on those 2 aspects would be appreciated. Thank you.
Okay, then yes, we go there.
First, I want to thank for the presentation. And then I have a question, but I'm not giving the question to an individual person. Anyone can answer between the panel. I'm from Somalia, and now I live in Greece, Athens. On the 7th of June, Greek Migration Ministry announced a list of some countries which they consider that Turkey is a safe country for them. These countries include Afghanistan, Pakistan, Bangladesh, Syria, and Somalia. And I don't know why all these countries are all Muslim countries. And for them, they cannot apply asylum in Turkey, and the Turkish government doesn't accept asylum applications. Does EU have a policy upon that? There is also some people who have been detained for 18 months in Greece before deporting back to Turkey. Is there an EU asylum law which says that the applicants must be detained before they send them back to Turkey or from the origin of their country. And if an applicant applies asylum, it must be based on the case, or it should be based on the nationality. Thank you so much.
Thank you very much for this technical question. You will get also an answer not only today, but later on in the different courses. And then I think that Lillian had a question that will be the last one for this round, but I already asked the persons following us online to prepare questions, and it seems that there are 2 questions. We will take them afterwards.
Thank you all for your presentations. My question is for Catherine. So we recently presented in the LIBE committee our new report with Odysseus on the EU's approach in the Mediterranean. And I was startled to see that the number of MEPs were actually asking us about what is the plan B if the pact does not go through, or we're openly contemplating, wouldn't we be better if we just stick to what we have and we just try to enforce it? And you outlined today also ECRE's, in a way, plan B or other way forward. And my question would be around the role of solidarity in this kind of plan B, as in trying to move around with the legislation as it is. I think you mentioned something like interim solidarity measures. So I was wondering if you could elaborate a bit more on your vision on this.
Okay, so then let's first start with UNHCR. Is Alexandra still with us online?
I'm here. Thank you very much. And thank you very much for the really good question. I have to admit, I'm not an expert in the SDGs, but what I can say about the importance of interacting with the Commission, with the member states, and with the US is the very important role of resettlement and safe and legal pathways for individuals to access protection in Europe and in the United States. It's great that the US under President Biden has once again rejoined its resettlement quotas. And also to do with the EU, we definitely welcome the leadership that Commissioner Johansson, the DG of Home Affairs, has provided in hosting what is going to be an upcoming high-level resettlement forum that will mark the 70th anniversary of the 1951 Convention. So we definitely hope that more member states can give pledges and that the resettlement needs in light of particularly the COVID-19 pandemic have increased dramatically. So we definitely encourage member states not only to submit more resettlement places, but to also adapt their processing. So, for example, some remote processing modalities, some ways of doing Skype interviews or other measures to meet the 2021 resettlement targets could be very useful, and also further scaling up much of the different technicalities needed for the resettlement programs. Complementary pathways are also a very important element of this. So this includes humanitarian admissions, labor mobility, education, and all at the same time ensuring resettlement is not substituted and remains the primary tool to provide protection to refugees at risk.
Thanks a lot for these answers. Now let's turn to Susan.
Hi, thank you. I think the primary question that I'll take on was the one around how do you get away from the politics of deterrence? I think this is a really important question, and one that's not just facing Europe, but actually facing the world more broadly. As Alexandra had mentioned, UNHCR has been tracking the effects of COVID on border closures worldwide. And I think the last time I looked at the numbers, there were more than 50 countries that were still operating border closures that have been put in place as a result of the COVID-19 pandemic and made no exceptions for refugees who are filing asylum claims. That means someone who arrives at a border can just be turned around without having their claim actually processed or accepted. And that number is quite high and has not decreased as much as one might have hoped, given that we are now more than 18 months into the pandemic and have quite a good sense of how to actually manage movements of people and processing of asylum claims in ways that are safe. And I think that's the result of a much broader narrative around asylum and protection and migration that has really become sort of captured by narratives of threat and narratives of fear, and has decreased some support for an understanding of the norms of international protection globally. There was actually a poll that was issued by Ipsos Mori at World Refugee Day, so last week, that looked specifically at support for norms of protection and for refugees worldwide, so around a number of different countries globally. And what they found was that while there was very high support among those they surveyed for protection in the abstract. So the idea and the principle that someone could leave their country and seek protection elsewhere, more than half of people simultaneously felt that their country in particular was full and should not accept any more refugees and should actually be turning people around. And that wasn't just limited to Europe and North America, but also some of the top countries actually where respondents were reporting that were in Turkey and in South America and elsewhere. So this is really a global challenge, and it's these sorts of public perceptions and public narratives and perceptions among politicians around the salience of these narratives that are driving the politics of deterrence. So I think what you have to do is really look at how do you tackle two things. First, how do you tackle perceptions of these sorts of narratives among elites? And second, how you tackle them among publics. And it's really a tricky question, because you have to deal with first understanding what feeds narratives of threat and perceptions of threat with regard to arrivals of refugees and those seeking asylum at borders. And then second, how do you actually begin to build more positive narratives around protection and around arrivals of those seeking protection? I think in terms of understanding what feeds narratives of threat, what Catherine mentioned at the beginning around sort of the reset that Commissioner Johansson is trying to achieve on this issue is really important. So decreasing the saliency of border management and migration and refugee issues in the public consciousness is really important, and helping to publics to really see this as sort of a normal course of doing business, not something that's exceptional. The arrivals of individuals at international borders to seek protection. And also, what's also been shown in public opinion research is that feelings of control and perceptions of control are very important to decreasing feelings of threat. So ensuring that that publics have a perception that what's happening at borders, again, isn't exceptional and isn't sort of the scene of chaos, and sort of governments are in control and know what's happening and who's arriving. The second piece around sort of building more positive narratives, I think here we've had a lot of learning of the last few years in the area of resettlement and complementary pathways that Alexandra mentioned. There's been an emerging body of research around things like community sponsorship in the context of resettlement, where community groups come together and welcome refugees and have sort of a participatory approach to helping and assisting someone after they've arrived. And I think there's emerging evidence around the role that that can play in helping communities to understand better where refugees are coming from, the role of the international protection system, and the challenges they face, and sort of beginning through individual contact to decrease stereotypes and negative perceptions. So I think what we, and I guess the other piece that Alexandra mentioned is also the role of complementary pathways. So pathways that actually enable refugees to travel for family reunification, education, or employment purposes, and help, I think, partly help communities and publics to understand refugees also, and those arriving as individuals who have their own stories and agency and sort of meaning and an ability to participate in their lives, and not just sort of victims of vulnerability and victims of sort of distant conflicts, but individuals who are coming to be part of a wider society. So I think these sorts of strategies have some promise, but it's I think a long road to go, and need sort of action on multiple different fronts, both in terms of countering some of these narratives of threat and beginning to look at ways that you can build a more sort of participatory process around welcoming and providing protection that helps to dismantle some of these stereotypes and negative perceptions. But we also have a few colleagues at MBI who've done a lot more writing and smart thinking on this around sort of what works and what doesn't in terms of dispelling some of these narratives. So I would also direct you to their work.
Thank you very much. And then the answers of Catherine.
Great, thank you. Let me respond to those questions in turn, starting at the front with conflict. I think this is why we emphasize that external policies of Europe and of the EU should focus on tackling the causes of conflict. And it's not the whole answer, but it's at least a better use of the funding and the power insofar as Europe has power in external affairs. And so that can be conflict prevention, supporting the security of people in different countries, implementation of the SDG, which you rightly mentioned. And I think there's a very high risk that if these policies are then diverted to deal with either securing agreements on deportation or trying to support governments to prevent people leaving or to prevent people crossing countries, it will actually lead to more displacement. These are counterproductive strategies. It's extremely long-term, complex effort to try to prevent conflict or to build up stability in a post-conflict environment, but there is a whole world of evidence about how to do that, and that should be the focus of external policy. We're working with a lot of Afghan organizations, including led by one of our policy officers who's himself an Afghan refugee, on trying to argue that, for instance, in Afghanistan, the focus should be a broader focus on trying to support long-term peace in Afghanistan, rather than allowing all of this attention and resources to be transferred to this question of deportation of people to a place that's not safe. And we also work with African analysts looking at the impact of these policies in their countries as well, trying to make the argument that it's actually not even in Europe's interest to do this. On the politics of deterrence, the idea of pull factors has this grip on the political imagination that just that cannot be shifted. And that's despite the fact that there's over 30 peer-reviewed studies that show that pull factors don't exist. The reason people move is push factors. But this conviction on the part of policymakers, which then leads to them putting in place policies of deterrent. To combat that, Susan mentioned some initiatives and things that take place. Evidence-based policymaking would be nice, but certainly in this area of policy, it's an area of policy that's particularly immune to evidence, I think, unfortunately. Nonetheless, we continue to propose that because you have to sort of believe sometimes in Enlightenment values and trying to do something that's actually rational and evidence-based. I think tackling push factors is also the issue, and those are the push factors outside the EU that we've just mentioned in terms of the causes of displacement, but also push factors within the EU. So, for instance, if an Afghan arrives in Europe to seek protection, the chances that they're granted protection vary from 3% in some countries to 98% in other countries, even when there's no objective differences in the cases. So that shows that decision-making is not working, that there's this asylum lottery, but that's a major source of push factor, Because if you're arriving, you're not going to stay in that country where the chance of being recognised is 3%. Similarly, if Greece doesn't spend a single penny on integration, this creates a push factor, doesn't it? That the chances of making a life there may be very limited and lead people to want to move on, as we see now with people who actually have protection status in Greece moving on out of there. Point at the top about the changes in Greece. We're extremely alarmed about the situation in Greece. And we just published something which is a paper called Beyond Judicial Control, which looks at Greece's lack of implementation of EU asylum standards in multiple ways. We're involved in legal cases right now on multiple different aspects of actions of the Greek government. I think we're challenging the Greek government in at least 3 different international courts and mechanisms. Right now, there's a big effort to try to get a court to throw out the decree that you mentioned that declares that that Turkey is a safe third country for certain nationalities. And hopefully, if a court deals with this, at some point that will be thrown out, because there's also procedural and administrative grounds. I mean, the minister doesn't have the right to just declare this. When it comes to the situation in Turkey, I think it's clear that in most cases Turkey is not a safe third country. Already the EU-Turkey deal is problematic in being based on the idea that it's a safe third country for Syrians. But if we look beyond Syria, of course, the temporary protection regime that exists in Turkey for Syrians does not apply to anybody else. And so I think there's no question that what is available there for non-Syrian applicants is clearly nowhere near protection standards that would be necessary for it to be a safe third country. So legally it's highly problematic. I know that's not reassuring when it's something that people face directly in their lives, but at the same time, there's efforts at least to try to prevent that being implemented, let's say. And then finally, on solidarity approaches. So I think that while it may seem naive, we continue with the same mantra that reforming Dublin is only worthwhile if it's properly reformed. And therefore, the whole RAM proposal, if it doesn't tackle the basic fundamental dysfunctionalities of the system, it's probably not better than the status quo. In the meantime, making the system work, I think, depends partly on proper respect for the hierarchy within Dublin, which is not impossible. That involves political decisions primarily to not jump to the default country of first arrival, but to go through the hierarchy to properly accept family reunification requests and so on, which in itself is a form of solidarity. And then emergency solidarity mechanisms. So there's been a discussion of the Malta Declaration. I would actually go back a few steps to the agreement that was brokered by France and Germany on accepting relocation of people who were disembarked. And at one point, I think 14 member states had offered some relocation places in some way or another. So we would propose a revival of something that's an informal agreement to be combining disembarkation and relocation. And as a final point, I think it's also about what's offered on both sides. If relocation places are offered, ports have to be open. There's no, the responsibilities under international law of the sea need to be respected. And then in exchange, a certain relocation numbers could be offered. And I think with the overall deal, it's something similar. The Pact deal on the table is we will offer you a small amount of solidarity, and in exchange you create this border infrastructure and keep people at the borders. again, we would say, well, to turn it around, some solidarity is offered to alleviate the unfairness of the Dublin system. In exchange, you comply with the law and you put in place decent reception conditions, you have proper decision making, and you don't engage in violent pushbacks, for example. So it may be well away from the political discussions currently, but I think those are the kind of ways that we would try to turn things around.
Thank you very much, Catherine. Well, with closing this session, I propose that we go to take 2 questions online, if the persons are still there.
The first one is on regarding skills and talents. So one short statement would be great. What do you expect? This is one question. And the other one is in relation with many ways to address implementation issues in migration and asylum policy without using legislative measures rather than soft law measures. Do you think that a shift to a soft law approach might be preferable given the current political context when new legislative proposals or revision of existing directives like long-term residence directive could actually result in a further watering down of safeguards and rights to third country nationals. Sorry, it's a bit long question. Hopefully, these are the 2 questions here.
Thank you. Actually, quite general questions. I don't, and not always related to asylum. I don't know who among the speakers would like to take one of or the 2 of these questions.
I'm happy to jump in.
Okay.
Yes, thank you. On the skills and talent partnership, I think it's good that within the Pact there are some sort of positive proposals, let's say, and that legal migration is seen as important. I would say something that might be contradictory and controversial. If we're talking about non-asylum legal migration, I think it can be problematic if this is Europeanized. It might have a gelling effect if there's an expansion of the use in certainly in the EU legal order of legal migration channels and so on. In the first panel, it was mentioned the slightly surprising fact, until you look at the geography, that Poland, for instance, is the country with the largest numbers of legal migration permits, let's say. And that's because there's 1.5 million Ukrainians in Poland, and then many other nationalities. The Polish government, despite its rhetoric, is frequently in the Philippines trying to attract migrants from the Philippines to come to Poland. So there is legal migration happening. It may not always be in the way that we want it. I mean, ideal. If we look at the situation in Ukraine, for instance, this is to some extent a displacement crisis, but it's one that hasn't caused political crisis and panic, because in many cases Ukrainians who are arriving in the EU are being granted work permits. And we don't propose that people be granted work permits instead of asylum. No, I mean, that's completely undermining the system. But there are multiple ways that things work sometimes. And some of that in terms of legal migration perhaps works better when it's outside of EU frameworks, because it's less complex and it may be less politically sensitive for some of the countries. So that doesn't mean there isn't a role for the EU. The EU might be funding, it may be sharing knowledge and good practice, it may be working, for instance, on implementing the directive on exploitation of third country migrant workers, all kinds of things where it can play a supporting role. It doesn't mean it has to go into EU law. So it's the skills and the talent partnerships, if they stay in that direction of practical, operational EU backing up member states' initiatives, that might be better. Similarly with integration and inclusion, there's a lot that can be done without, it's not an EU competence, there isn't EU law on that, but the EU can be stepping in to provide funding, to insist that EU money is spent on integration, not on return, and other things. Because to some extent we may be in some of these areas at the limits of harmonisation. So the question is more EU better when it comes to protection or not? And if the standards go down in EU law, if the number of places offered for safe and legal arrival goes down, then actually a protection answer might be to be working outside of EU law. And finally, on compliance, that was the last question there. This is the big issue and one that everything struggles with. At the moment, we and others rely a lot on courts to ensure compliance with the law. We and many others, we run strategic cases at the Strasbourg Court of Human Rights, and we support cases going to Luxembourg Court of Justice of the EU, UN mechanisms, highest level national courts. Those are strategic cases trying to get decisions that then have a positive impact on potentially hundreds of thousands, if not even millions of people. And then day to day, we're advising asylum lawyers on individual cases. And so much of getting compliance, unfortunately, is about getting courts to make decisions. So much of people accessing their rights is about litigation. That's not ideal. There are other ways to ensure implementation of EU asylum law. So a stronger role, for instance, of the European Commission, not infringement proceedings, yes, but also all the steps before that, support, highlighting political action. But again, the politics come into play. If all the other member states are relying on Greece to contain people, then Greece can act with near impunity, unfortunately. So I think we come back to the politics. I'll leave it there. Thank you.
Thanks a lot, Catherine. Well, this means that you're not that much in favor of soft law, which was also part of the question, by the way. Tomorrow morning, we have a PhD seminar, and if I remember well, we will have one PhD project dealing with soft law and readmission, and you might get more answers. So tomorrow morning, if you want to join us. Now, it's a bit later than expected, but it was a quite long afternoon. I imagine that everybody's brain is a little bit tired. So it is the moment just to cross the street and to go to the Institute for European Studies for the cocktail. I don't know the weather outside. Will it be in the garden or will it be inside? That will be the surprise.